Hello. Our latest question here was about foreign marriage and divorce recognition. And to give you the first and very short answer, uh, foreign marriages and divorces are usually recognized in Canada. So you don't need to do anything specific to have them recognized. If you are married in the United States, in Belgium, I don't know, in Senegal, in India, in Japan, so the very fact that you have a properly issued by, again, appropriate authorities issued marriage certificate or any other document attesting, like legally attesting your marriage in that jurisdiction, usually it's quite enough for Canada. Uh, there might be some caveats about that, but as a general rule, it's like this. Same story is about divorce. Again, as long as you were properly, legally, by a competent authority, divorced in some other jurisdiction, uh, again, usually it's recognized in Canada. Uh, and if you just fall within this vast majority of the cases, probably you don't have anything to worry about. But there are nuances that you should know, or should at least think of. And if you think that those nuances might be within the limits of your case, within the framework you're in, then there might be a good idea to consult a lawyer. Depending on the province in Canada, it might be a lawyer in Quebec, or a lawyer in another province, because family matters, even though divorce itself is governed by the federal Canadian Divorce Act, still family matters are usually governed by the provincial laws, provincial rules, and very often you have to consider exactly those provincial rules first, because, well, again, divorce provisions are, in general, are more or less all the same all over in Canada, but the consequences of divorce, well, again, at the end of the day, it will be more or less the same, but the way you get there might differ. Uh, so what you might be interested to think about if it comes to a foreign marriage and foreign divorce. Uh, in Canada, you can be only married once at the same time. So if you're already married, and if in some other jurisdiction you got another marriage, which is allowed in that jurisdiction, that will be invalid usually in Canada because it goes against public order. So in case, if ever, the question of your last will, for example, come up, or some other property division issues, in Canada, a valid spouse would be that of your first marriage if there was no proper divorce. That's the major major point. But again, sometimes marriages, as they are allowed in some foreign jurisdictions, are not allowed because of incapacity or age, for example, in Canada. And in that case, that marriage might become problematic. Also, when it comes to marriage contracts or prenuptial agreements or postnuptial agreements, some of the provisions would be still quite valid and recognized in Canada, but some might go against Canadian public order when it comes to, like, property division, particularly in Quebec, for example, whatever is stated there, so-called family patrimony, which includes family residence, residence furniture, or residences, if there are more than one, cars, pension plans, whatever is your marriage contract, those assets are usually divided by the provisions of the Civil Code of Quebec anyway. Uh, when it comes to a divorce, again, the very fact of divorce is usually recognized in Canada, though there are some limitations, because, for example, in particular province in Canada, you can apply for divorce if you lived in that province, like resided officially for at least 1 year, 12 months, and about the same is applicable about foreign divorce jurisdictions, at least one of the spouses. But there is usually the country of origin, at least in Quebec, it's recognized. So there are nuances in that. But as long as the divorce was, again, authorized by proper, competent body in that country, as long as it was legal there, you have pretty good chance that it will be okay in Canada as well. If only because of this forum shopping provisions and for forum shopping concerns, uh, if one of the spouses would not contest it and protest against that. But, the very fact of divorce is not that much of a matter. Like, what gives you your divorce? A right to get married again, but more or less that's it. The most important part of a divorce is usually, most important questions usually about the so-called accessory measures, like spousal support, child custody, or parenting time, as it's now called, property partition, but for that family patrimony, for example. And what laws should be applicable, because again, the Civil Code of Quebec, if you are considering it in Quebec, I mean, has its own public order provisions and expectations and so forth. So divorced you are, even if you're divorced somewhere else, you're most probably divorced by the legal glance in Canada, by a legal appreciation of your situation. But what are your obligations following that divorce? That might differ. And even some court in some like other country far away from here would grant you it all, like all the property, no obligations towards your spouse. But if your spouse then goes to Quebec, resides here with children, without children, that spouse might apply here in Quebec to correct those accessory measures. And accessory measures, as opposed to judgment of divorce, are supposed to be subject to judicial modifications after. So it might be that divorced you are, but at least in Canada, even though you are properly divorced in some other jurisdiction, you might become subject to some obligations that you are not expecting, for example. Similarly, if you get some accessory measures there in that jurisdiction, but for some reason Canadian courts, particularly Quebec courts, would see that some procedural rules were not observed, like Hague Convention notification, for example, that foreign decision might not be recognized here in Canada and Quebec. And by the way, it's vice versa. If some other country's court where you then just fled or simply just traveled or decided to move, suddenly comes to an opinion that the decision as it was made in Quebec was not recognizable by that foreign authority for whatever the rule is there, then you might need, continuing to be divorced, but you might need to relitigate before the local court the consequences of your marriage. So it goes, cuts both ways. It goes there and here. And one other thing of this foreign marriage or divorce, particularly divorce, that should be taken into account is that situation with your children. Because even though you're legally continuing to be parents, moving a child from one country to another, but for some short travel time, usually requires a court authorization. And for example, you took your child for a vacation to some like foreign jurisdiction, then you decided to stay there, thinking like, okay, well, I'm a parent, but what can go wrong? But if the divorce provisions, and particularly the accessory measures provisions, were treating this child as a resident of that other country, be it Canada if you left Canada, or be it, for example, I don't know, United Kingdom if you went from there to here, then such unauthorized move of a child might be seen as abduction of a child. And even though it comes from one parent to another, there might be a court proceeding and there might be an urgent court decision ordering to bring child back and so forth. So even though you as a parent might think that you're not doing anything illegal, this question of crossing border, even sometimes crossing the border of a province from one to another, might suddenly bring up a question of a child abduction. But those are nuances, and of course you should consider them. But all in all, if you got properly married and divorced in some foreign jurisdiction, particularly, for example, it's your country of origin, then you don't need to do anything specific to get your marriage or divorce recognized in Canada. Normally, but for some specific particular contestation, normally it's valid as is. Thank you and have a nice day.